Hi, my name's Sharon Mackay. I'm the Head of Family Law Department at Taylor Bracewell. So the divorce procedure changed on the 6th of April of this year, and what that did was introduce a huge change to the divorce procedure for the first time really in 50 years. And under the old procedure, the marriage still had to have irretrievably broken down. And if one party believed that, they had to rely on one of 5 reasons then for the divorce. And the reasons included 2-year separation, 5-year separation and desertion, but the main grounds would often be unreasonable behaviour of one party or adultery of one party. And so for years there were solicitors and bodies like Resolution were campaigning to introduce a no-fault divorce. And it was introduced in other parts of the country and the world some time ago. So from April, the law completely changed. And then the only ground that you have to say that the reason for the marriage breakdown is that the marriage has indeed broken down. You no longer have to give any sort of reason. You just have to give a statement that the marriage is irretrievably broken down. And in fact, the parties can, for the first time ever, do a joint statement that the marriage has broken down. Now, the step-by-step guide is really that once you feel that the marriage is broken down, you can deal with a divorce, and that can be done mainly still online. You would need an original marriage certificate because that has to be uploaded to the system. You need to look at paying the court fee. Now, the court fee at the present time is £593. There's also an online form that you can complete to try and reduce the court fee depending on your income and savings. So once you have the marriage certificate uploaded, you would need to log on to the court server and then look at completing the online application for divorce. Now, once you've done that, the other party would then be notified that you've done that, and they will be asked to set up their own online account to be able to respond to the divorce. And then there is really a waiting period. So from the date that the application starts to the date that you can finalise it, there has to be a waiting period of 26 weeks. Any time after 20 weeks, it's possible to apply for a conditional order. That used to be known as the decree nisi. And then after the 26 weeks, you can apply for a final order, which used to be called decree absolute. Now, with a petition under the old procedure, it was possible for the respondent, that's the other party, to defend the divorce. They might want to have said that they didn't feel that the marriage had broken down. It might be that they didn't think the marriage had broken down for the reasons that you set out in your petition. They might have disagreed with, for example, the particulars of behaviour. And so it was possible for them to file a defence, and then they could answer your petition. Now, with the current procedure, it's no longer called a petition, it's called an application. It isn't possible to defend the application, and that's because there is no reason. So it's possible in very limited circumstances to dispute the application that's made for the divorce, but you can no longer defend it. Now, it's really important still to have some guidance when you're dealing with the divorce procedure, because when you're filling in the online application, you have to be careful to think about the cost of the divorce, to think about the financial side of it, and there are particulars in there that you do have to complete. So although it is a step that you can take in person, it's always advantageous to have some advice about the process either before or at the time you're completing it, or to instruct a solicitor to complete that process for you. Thanks for watching. I hope that was valuable. If you want to contact us about any more family law issues, please get in touch using the details on screen.